September the 18th, 2017, 4 p.m. in council chambers. So I will call the meeting to order, and first I will read the statement from the chair, and read it on here rather than in the book. So the statement of the chair at a public hearing. This public hearing is convened pursuant to Section 464 of the Local Government Act, RSBC 2015, to allow the public to make representation to council respecting matters contained in Foreshore and Lake Regulations, Foreshore and Lake Zoning Amendment Bylaw number 1294.02, 2017, OCP Amendment Bylaw number 1230.20, 2017. Every person present who believes that their interest in property is affected by the proposed bylaws shall be given a reasonable opportunity to be heard respecting matters contained in the proposed bylaws. None of you will be discouraged or prevented from making your views known. However, it is important that you restrict your remarks to matters contained in the proposed bylaws. When speaking, please proceed to the microphone and commence your remarks by clearly stating your name and address. If you do not wish your entire address to form part of the public minutes, please state so for record-keeping purposes only, and only your street number will be recorded. Your full address will still be kept on file with the town. If they wish, members of council may ask you questions following your presentation. However, the function of council at this public hearing is to listen to you rather than to debate the merits of the proposed bylaws. In accordance with the council procedure bylaw, presentations by members of the public shall be limited to a maximum of 5 minutes each. If a person has additional information that he is unable to provide within that time frame, he shall be given further opportunity to address council after all other interested members of the public have been heard a first time. Please refrain from applause or other expressions of emotion during this public hearing so that we may ensure as impartial a hearing as possible. After this public hearing is adjourned, council members will not speak to the public on this matter until after the matter has been dealt with at a public meeting. After this public hearing has concluded, council may, without further notice, give whatever effect council believes proper to the presentations made at this hearing. I'm now going to do the confirmation of advertising and posting requirements. Notice of this public hearing was given in accordance with the Local Government Act and the Community Charter by distributing the notice as follows. Publishing in two consecutive editions of the Osoyoos Times on September the 6th and September the 13th, 2017. Placing the notice on the bulletin boards in the Town Hall and Planning and Development Services Department on September the 6th. Posting on the town's website September the 6th and distributing via e-news on September the 7th, 2017. So next we will ask for a report from our Planning and Development Services. Ms. Huang.
All right, thank you. So as a background, Council has given first and second readings to the following two attached bylaw amendments to improve our foreshore and lake regulations, and which are the subjects of this public hearing. And those include Foreshore and Lake Zoning Amendment Bylaw number 1294.02, 2017, which relates to housekeeping improvements, and Official Community Plan Amendment Bylaw number 1230.20, 2017, which relates to Foreshore and Lake Development Permits area. Council has also given first, second, and third readings to the following two bylaws, which are not part of this public hearing because they are of an administrative nature, but they are attached to the hearing package for sake of transparency. And these include the Lake Use Procedures Amendment Bylaw number 1235.06, 2017, for the implementation of the Foreshore and Lake Development Permits area, as well as the Municipal Ticketing Information System Amendment Bylaw number 1279.12, 2017, also relating to the Foreshore and Lake Development Permit area implementation. To provide an overview, following as an overview of the proposed package of Foreshore and Lake regulation bylaws attached to this report. So relating to the Foreshore and Lake zoning bylaw, after 5 years of experience with our Foreshore and Lake zoning bylaw, it is timely to make some housekeeping amendments. Council approved our bylaw in 2012 following public stakeholder recommendations the previous year from our Lake Recreational and Commercial Use Task Force. Bylaw objectives include sustaining a Soyuz Lake for the health of local fisheries, safe and orderly recreational and commercial use, and the town's continued attractiveness as a resort community. Our bylaw applies across the riparian foreshore and out to our municipal property in the Soyuz Lake, which typically is about 100 meters from the shore. 4 zones are demarcated. W1, public water use, including the protected swimming areas. W2, private moorage, typically for single-family homes. W3, group or strata moorage. And W4, commercial moorage. In the same fashion as land use zoning bylaws, each water zone has its own development standards, and a zoning amendment and public hearing is required to accommodate different uses not permitted under current zoning if requested by an upland waterfront parcel owner. The various housekeeping improvements proposed for this bylaw would bring us more into conformity with provincial regulations, round out regulatory requirements, and adds clarity to some text. Moving on in terms of the Foreshore and Lake Development Permits area, it is proposed to add a new Foreshore and Lake Development Permits area into our OCP to promote environmentally sensitive design of private moorage facilities and to complement the town's Foreshore and Lake zoning bylaw and riparian development permit area. As explained further below, these new permits will especially compensate for a diminishing provincial regulatory role regarding private moorages. The Provincial Ministry of Forests, Lands, and Natural Resource Operations has a very different approach in terms of dealing with what it distinguishes as specific permission and general permission applications for installing moorage facilities. The ministry directly reviews all specific permission applications for larger moorages such as group, strata, and commercial facilities, and also refers them to local governments for checking against their particular requirements. Control of private moorages is another matter. In those cases, the ministry automatically grants a general permission if property owners conform to basic blanket conditions. This means that the province, and by extension local governments, can be unaware of what private moorages are being built. In the view of many affected local governments, this regulatory shortfall worsened with the ministry's announcement on January 17th of this year that general permission exclusions were being broadened with only a few area exceptions. To enable this shift, the ministry removed their previous service limit of 24 square meters for private docks, and this is the same as in this requirement is the same as in our Foreshore and Lake zoning bylaw, and now exempts docks up to 120 square meter in size from review depending upon their individual design parameters. Staff recommends that we emulate the long-established practice of the Columbia-Shuswap Regional District of requiring development permits for private moorages by instituting our own similar Foreshore and Lake Development Permits area. The ministry assisted us bringing the permit guidelines up to best practices. Like the Columbia-Shuswap Regional District, we do not advocate duplicating the province's mandates for specific permissions of larger moorage facilities. With regards to the Land Use Procedures Bylaw, some amendments are required to our Land Use Procedures Bylaw to assist implementing Foreshore and Lake Development Permits. That is to add this new type of permit to the Director of Planning and Development Services delegated authority for approving development permits. included on the development permits application form, and charge a permit fee of $250 as stipulated by council at their July 4th meeting of this year. In terms of the municipal ticketing information system bylaw, lastly, amendments are also required to our municipal ticketing information system bylaw to primarily add offenses and fines for commencing work without a foreshore and lake development permit. With regards to impacts for the community, consistent, clear, and effective regulations will contribute to achieving community foreshore and lake objectives and will create a level playing field for all users. Organizationally, additional demands on planning and development services staff for new development permits are unknown at this time, but should be manageable. In terms of budget, development permit fees will assist in defraying the costs of additional town services. Significant dates, timely action is needed to cover off a regulatory shortfall for private mortgages. Future bylaw fine-tuning could be possible by learning from practice. And lastly, in terms of sustainability, long-term environmental sustainability of Osoyoos Lake is a primary concern of our community sustainability plan.
Thank you very much, Ms. Wong. And I'm going to identify that some correspondence was received from the Casa del Lago strata. That has been included in the package, so I will not read that. We're now going to have some public presentations, and I will go through the list of people who have signed up in the order that they signed up. Please, as you heard, say your name and your address when you come up, and restrict your remarks to 5 minutes. Mrs. Hilson will keep track of that. Thank you. And then we'll go on to the next one. As you know, everyone will have a chance to state what it is, and council will ask questions if they deem it necessary. Okay, so the first person that I have on the list is Byron Karen, who is from Cottonwood Drive, who I believe wrote the letter on behalf of Casa del Lago. Would you like to come up to the microphone, please?
Yes, I'm Brian Caron, 310 7600 Cottonwood Drive, and I'm the president of the strata at Casa del Lago, and I'm here representing them. I guess our concern is that on just one item in the 1294 amendments, item 3.6 is hardly a housekeeping change, and I'm glad to hear the word housekeeping used so many times tonight, describing the purpose of this meeting. It's a very substantial change, going from letting boat lifts be in the water to now all of a sudden requiring you to build a dock and be within 0.5 meters of that dock. And you know, I would like to know what the basis of making that change is. And you know, as I say, it's hardly a housekeeping change. It's very significant for us. And I'm assuming it's somehow tied to environment, and I'd love to see the environmental study you've done to prove that you need to build a dock to have a boat lift in the water. And so I've written, I think, everything else that I have, and I just like, you know, that's our concern.
Thank you. Anybody have any questions? No, it's there. The next person is Derek Kalfas. Am I correct in saying that?
Derek Kalfas.
Okay.
Yeah, my name's Derek Kalfas. I live at 221 7600 Cottonwood Drive. I'm a past president of the Strata Council, and I just found out about this recently, came back today so I could be at this hearing. It is hardly a housekeeping change that's proposed, requiring that the lifts be less than half a meter from a dock. That would impact on 50 families directly in our complex, meaning their quality of life, their ability to enjoy the summer, not even accounting the significant proposed decrease that would happen in property values by not having the ability to operate our boats in front of our property. And I don't think any thought was given to this whatsoever, the impact, not only in Casa del Lago, but I'm quite certain, having toured the lake many times on my boat, that there are a lot of other properties that would be impacted by that housekeeping change that you're proposing. And not only the 50 boat owners in Castle, but there are 180 units. I own 2. There are many of us that have multiple ownerships there. It's a significant tax base to this community, and to suddenly be told or proposed that we can't have our boats out there is a very, very significant change, not a housekeeping issue. Thank you.
Thank you. Next is Rod Griffiths.
Afternoon, my name is Rod Griffiths. I live at number 13, 7200 Cottonwood Drive. I'm the president of the Strata Council there at Soli Vita. Our concerns were to make sure that in this housekeeping, that right now the way it's stated is that they're not allowed to have any buoys within our foreshore. We just wanted to make sure that's still going to be upheld the way it's written right now. So that's our only concerns as of now.
Thank you. I see Ms. Wong writing down all the concerns that that you're bringing up. So she will deal with this after. The next person is, I'm sorry, I cannot read the writing. 9405 Spartan Drive.
Okay.
And I apologize, but you did it in writing. Would you like to come up?
No, I'm fine. Okay.
You're okay.
Yeah.
All right. And could I? So you don't want to. All right. How about Joe
Yes.
Domagen? Thank you.
9209 Spartan Drive. I have one question. I was unaware of this till today, or last night. By reading this and listening, we are allowed up to 120 square meters per lot for a dock. Is that correct?
Ms. Wong, would you
I
like
understand
to?
that is in terms of the province eliminating the 24 square meter dock requirement.
So, but you're saying it can go up to 120. Is that correct?
That would be exempted from the general permission route through the province. We still have the 24 square meter requirements in our foreshore and lake zoning bylaw, though.
So where does this 120 come in? I don't understand. I thought that is a new proposal.
I'll have to look into that. That is in terms of
prevent.
yeah.
Point. If I can put 120 square meters in front of my lot, my neighbor's lot, and all the way down this lake, where is the beach going to go, and what's this riparian all about? That's 60. That's 60 by 1,200, 40, correct? 40. My math, I'm at 20. Pardon me. 100. It's 1,300 square feet is 120 square meters, correct? Very close. So if everybody still have 1,300 square feet in front of their house, I don't get it. So I don't understand what this is about, that part of this conversation.
Well, thank you for noting that, and it will certainly be looked into. And Ray Renault?
Good afternoon. My name's Ray Renault. I live at 3613 Jasmine Drive. I just have a question more than anything else. I knew that this event was taking place, but I wanted to make sure that the bylaw, especially the recommendations at section 2.2, where we're allowed each semi-waterfront property owner between Jasmine Drive and Acacia Court, but not beyond, to apply for a town permit for mooring one boat per property in the town lease area by means of a combination from two of either a dock, boat lift, or buoy, and that each application would be for a non-transferable permit with a one-time fee. If a property was sold, the new property owner would have to obtain a new permit and repay the fee. So I'm quoting from that proposed wording. First of all, I want to know if there's any change to that. Can anyone tell me that at this point?
That is, sorry, go ahead, Ms. Wong.
Sorry, you're referring to is it under section 5.1?
Section 2.2, page 4 of the November 5th, 2012 Committee of the Whole Staff Report, where it states, and it did become part of the business plan for the town, because it was an item listed on that business plan. I have that also.
I believe you're talking about 5.1, W1, public water use, site-specific, which is what Jasmine Drive and Acacia Court properties are, because there is a road allowance in the front, which belongs to the town. So it's not specifically waterfront property. It's kind of called semi-waterfront or something. Do you see that in the report? It's on page 6 of 16 is what
Yes.
I have. Yeah. Okay.
Yeah, so in terms of the wording, what is proposed is that provincial approval is also required. So from my understanding, a lease has not been put in place yet. So because those lots off of Jasmine Drive and Acacia Court, those are not considered to be waterfront parcels, but rather semi-waterfront parcels. So the requirements are in that the provincial requirements usually they only require private moored facilities for waterfront parcels. In this case, the town is the upland owner fronting along those properties there. So the provisions are different, and provincial approval would also be required as well.
So what does that mean? Does that mean that all of the assurances we were given have since changed, and now there's a new requirement? Approval to have a boat dock in front of the property?
Yeah, you were referring back to a committee of the whole
Yes.
report, right? I would have to take a look at that report.
Okay. Because it was also forming, excuse me, I don't want to take too much time, there's a lot of issues here. But it's also forming part of the business plan that I brought a copy of, and I'll show you what I mean. I just brought one page of it. It's that document there.
Okay, thank you.
So anyway, those are my questions, and I wasn't made aware of there any changes. I've got emails back and forth with Elaine Cunningham. I'm sorry he's not here, because I'd ask him directly, but I pressed him for 2 consecutive years, because there was a promise of an agreement and a letter to formalize all of this stuff that we battled back in 2012. Never happened. I finally quit calling him. And now I learn that we also have to have provincial approval, and I have no idea what that means, because we only discussed it within the town. So those are my questions, and I'd like some answers, please.
Thank you.
Okay.
Is there anyone else who would like to speak to council at this meeting? Yes. Please come forward, state your name, and
Hi, Rupert Weiser, Unit 26, 7600 Cottonwood Drive, from Casa del Lago. We're fairly recent purchasers there, but the comments I've had from a lot of people is that this change in rules will dramatically affect their property values and create undue hardship on people, because now the enjoyment of the property will not be the same if we're not allowed to have boat lifts there. And a dock will create a massive expense for the community. So that's what I wanted to bring up.
thank you very much. Is there anyone else who would like to speak? I'll ask for the second time. Is there anyone else who would like to speak? And for the third and final time, is there anyone else who would like to speak? Okay, and hearing none, then I will declare that the meeting is concluded, and could we please have a motion to adjourn? Thank you very much, Councillor Campbell and Councillor King. Thank you to all of you for coming.
Could you explain the next steps?
Mr.